Our first panel is here to discuss the national perspective on the competency restoration crisis. As many of you know, the competency to stand trial process is designed to protect the rights of people who do not understand the charges against them and are unable to assist in their own defense. Many states across our nation, including Texas, face a growing crisis in effectively serving the number of people waiting in county jails for inpatient competency restoration services. This process has become increasingly costly, overburdened, and delayed, as you all have been hearing about for the last few days. It takes a significant toll on the health and well-being of individuals waiting in jails for services and on the scarce resources at the disposal of the behavioral health and justice professionals. Our first panel this afternoon will discuss how states across the nation are working to improve bed wait lists of defendants who have been court-ordered for competency to stand trial evaluation or restoration services. They will explore recommendations on how to prevent this national crisis of pretrial defendants, sometimes charged only with misdemeanor offenses, spending far longer in jail than they ever would have had they pled to or been convicted of their underlying offense. Here to discuss the crisis from a national perspective is Nanji Waller and Rick Schwermer. Judge Nanji Waller was appointed to the Multnomah County Circuit Court bench in 2001 and served as presiding judge for 6 years. She currently is the mental health court judge, co-chair of the Chief Justice's Behavioral Health Advisory Council, and serves on the Governor's Children's Cabinet. She is also a member of the Oregon Judicial Department's Judicial Leadership and Education Committee. Judge Waller could not be here in person, so she graciously sent us a video message for the summit. Here in person, we do have Mr. Rick Schwermer. Mr. Schwermer is a consultant and faculty for the National Center for State Courts and the National Association of Drug Court Professionals. He has been involved in all aspects of court administration for over 30 years. Mr. Schwermer is committed to translating research into effective evidence-based practices in a variety of contexts, including court case management, behavioral health issues in courts, pretrial reform, and problem-solving courts. With that, Mr. Schwermer and Judge Waller.
Thank you. Steal that. Thank you very much for that kind introduction that I might have written some time ago. Where did Chris go? I did want to just give a quick shout out to Chris. He's probably, there you are. Thank you. If there's one thing I've learned in the 2.5 years I've been working on this project, it's that peers are absolutely vital to all parts of the process, and I thank you for sharing your story in the way you did. And if I get a Be Bold tattoo, it'll be my first. So thank you for that. Thank you for that suggestion. So competency is a crisis. It's absolutely a crisis in every state. And so I think we were asked to talk today about the national perspective. And as I mentioned, for about 2.5 years now, I've been working on a project, excuse me, with the National Center for State Courts. And the first topic that we picked, we're looking at the entire issue of behavioral health and the justice system and that intersection. And the first topic that we picked, because it is such an important one, is competency to stand trial. You'll hear, by the way, Judge Waller in her video talk, they have a different term, they call it aid and assist in Oregon, and there are different terms across the country, but the problem is the same, that we're putting way too many people for the wrong reasons into this competency process, and we're making them worse. We're making them sit in jail, our most vulnerable people for whom jail is the absolute worst place to be, where they don't get medication, they don't get treatment, they're associating with the high-risk individuals you heard about yesterday. And then we're surprised when they recidivate. We're surprised when they act out in jail, in prison. It is a national crisis, and it is something that we all need to address. The other thing that I've learned in my 2.5 years is that there are best practices. There are ways in which we can change the system. We can lead reform. Judges are a part of that. You all are a part of that. So we've developed resources that I want to make sure that you're familiar with. National Judicial Task Force that I mentioned is the chief justices and state court administrators from each of the 50 states plus territories. And they created a task force to look at this issue and others. And most importantly, what I've been doing for those 2.5 years is accreting resources, because there are resources, as I mentioned, that tell us what those best practices are. So I'm going to share some of the resources at the very end. But one of those resources relative to competency is a paper that I wrote with the help of this same committee of 8 judges and a subcommittee of the National Center for State Courts Task Force, or the CCJ-COSCA Task Force, that just focused on competency and what we can do. And we have 10 areas of recommendation. The link is at the top of this. I think you all have this in your materials somewhere, but ncsc.org/behavioral health. And then if you go to task force publications, I think the first one's still listed there, because we just adopted it, the full task force, just a couple of weeks ago, or a month ago. So I encourage you to take a look at that. That's the paper that Judge Waller is going to be talking about in her video presentation. And I do also, on behalf of Judge Waller, apologize she couldn't be here and couldn't be here remotely live either. So I hope you'll bear with us with this video presentation. It's about 22 minutes. In the meantime, as questions come up, both for folks in the room and the folks online, got my computer up here. I'm going to check for chat questions. Please ask questions. I'm glad to chat about them afterwards. And then again, share where those resources might be. You can follow along at that link that's in the PowerPoint now. So if we're ready to roll the video, thank you.
Good afternoon. My name is Nan Waller. I'm a circuit court judge in Multnomah County, Oregon, and a member of the National Task Force to examine state courts' response to mental illness. I regret not being able to attend in person. I understand from a recent State Justice Institute newsletter that Texas is launching an Eliminate the Wait initiative to address the more than 1,500 people you have waiting for competency determination. I look forward to learning from your efforts, as I am a firm believer in borrowing and duplicating efforts that have proven successful in other jurisdictions. Today, I'm going to review the recently approved competency recommendations from the National Task Force. The recommendations can be found in Leading Reform, Competence to Stand Trial Systems. Before doing so, I want to set the stage by providing some examples of how the crisis plays out. Then I'll briefly review all of the work that preceded and helped inform the recommendations, and then I'll go over the recommendations with some examples from my own jurisdiction as to how those recommendations can be carried out. As you know, it is a central tenet to the criminal justice system that a defendant must be competent to stand trial. The concept of competency as being necessary before the state can prosecute dates back to at least mid-17th century England and originated from the dilemma of defendants who could not or would not enter a plea of guilt or innocence but would stand mute. The 17th century process of determining whether the defendant's refusal was volitional or not was to pile stones of increasing weight upon the chest of the defendant, with the idea that if they cried out, they were obstinately mute and the prosecution could proceed. But if they remained mute, it was by visitation of God and the prosecution did not proceed. We've clearly made progress in how we determine competency since that rather crude and often lethal process. But for any judge who's visited a jail where the mentally ill are being held pending competency, it is also hard not to acknowledge that we face significant problems in our competency systems. I handle all of the competency hearings for our court, as well as managing our mental health court. That perspective, provided by handling both competency docket and mental health court, quickly led to an epiphany moment for me, that the crisis in the competency system is the canary in the coal mine for the crisis along all points of the intersection of the behavioral health and criminal justice systems. Too many mentally ill people end up in the criminal justice system for lack of other options and are then funneled through the clogged competency process, often with too few options for them once they are restored to competency, with the result being that some defendants cycle back through the competency system repeatedly. And in fixing any one part of the intersection of criminal justice and behavioral health, we need to be cognizant of the impacts, both unintended and intended, on other points of intersection. The hydraulics of the behavioral health and criminal justice system are complex. I'm not sure if all of you hear competency determinations, but for those of you who don't, I'm going to give you a quick grounding in how the crisis plays out. For those of you who handle competency matters, this will likely sound familiar. The two cases I'm going to use as illustrations are on opposite ends of the risk continuum, and yet both represent systemic failures. The first was initiated by a call from the jail asking if I would do an emergency jail-side hearing for an individual with very serious charges for whom they had grave concerns about his competency and how his mental health was impacting his physical health. What greeted me is a sight that is forever seared into my memory. A naked man tied to a restraint chair with a spit wad in his mouth. Even with the spit wad, I could hear his delusional, nonsensical rants interspersed with moans. The deputies and jail medical staff explained that his behavior had necessitated the restraint chair to keep him safe, and the spit wad was to keep them safe, and that they were afraid for his health because in his delusional state, the man had refused all food and water out of a belief that it was poisoned. Based upon what I was seeing, I did not think that the staff were being alarmist when they indicated they were afraid they could not keep him alive while waiting for transport to the state hospital for restoration. The jail had contacted the state hospital and they had refused his transport. No room at the inn. The second example is of a man diagnosed with schizophrenia who had a fixed delusion and obsession with the airport. He'd been trespassed from the airport, but would repeatedly head back and create a fuss. The police would be called. He would be arrested for trespass, a crime with a maximum penalty of 30 days in jail, booked into jail, charged with trespass, not released because of his history of failing to appear, appointed a lawyer who, upon trying to meet him, would have significant concerns about his fitness, and then arrange for a competency evaluation. After a finding that he was not competent, the state would agree to dismissal because the charges were not serious enough for commitment to the state hospital for restoration, and he was too disorganized to participate in community restoration services. Over the course of a summer, I dismissed close to 70 trespass charges, and the results? A significant cost in court-appointed lawyers, the jail, evaluations, and even more importantly, an individual who received no treatment and no sustainable solutions for the nuisance he was creating repeatedly in a public setting. Eventually, and unfortunately for the man, or perhaps fortunately, because he got services, his mental health deteriorated to the point where he met the standards for civil commitment. As the numbers of defendants entering the competency system increased across the country, creating an ever greater crisis, in 2019, the National Center for State Courts invited a group of judges from around the country to examine competency practices and policies. I jumped at the chance to participate, hoping other jurisdictions would offer solutions for what I was seeing. Instead, the meetings led to another epiphany, that the system problems that I was seeing every day in my courtroom were not unique to my jurisdiction. Across the country, the impact of the crisis in the competency system was playing out every day. Overcapacity state hospitals with long waiting lists, jails that are often the largest mental institutions in a community, and on our sidewalks and our streets where many defendants land untreated, unmedicated, and unhoused. The states that the 8 judges who comprised the focus group were drawn from all had different processes for competency assessment and treatment, but all were feeling the strain of an overburdened system. From our different perspectives and practices, we were, however, able to come to consensus that we needed to reduce the numbers of people with mental health issues for whom the criminal justice had become the de facto door to mental health services by increasing services in the community, that there's a need to deflect and divert mentally ill individuals from the justice system, and that for those persons who do end up in the criminal justice system, we need to take steps to assure that the long waits that occur at every point are reduced. The circle of inquiry into competency was broadened when the Council for State Governments convened an interdisciplinary group including judges, psychiatrists, policymakers, and many others to consider the competency crisis in October of 2019. The recommendations from that meeting were incorporated into the report Just and Well, Rethinking How States Approach Competency to Stand Trial, published in October 2020 by the Council for State Government in partnership with a number of different organizations at the national level. In March of 2020, The next step was that the Conference of Chief Justices and Conference of State Court Administrators passed a resolution establishing the National Task Force to examine state courts' response to mental illness, with a charge to study the impact that individuals suffering from mental illness have on operations of state judicial systems and to make policy and practice recommendations to improve the response of state courts. Establishment of the National Task Force grew out of the work of the National Initiative Advisory Committee, which is documented in the Council for State Governments publication, The Future is Now, Decriminalization of Mental Illness. The task force consists of 3 work groups: criminal justice, civil, probate and family, and education and partnerships. I sit on the criminal justice work group and serve on 2 of its subcommittees, competency and diversion. I've taken the time to do a quick review of what led to the establishment of the task force and what is happening at the national level, because I believe that this both highlights the elevation of the competency crisis at the national level, given the depth and breadth of the crisis, and underscores the urgency of the crisis. The committee's competency subcommittee's recommendations were approved by the Executive Committee of the National Task Force in September of this year. And that is where we all come into the picture as state court judges. The hydraulics of the competency system are complicated, and the changes recommended by the task force require good collaboration between all 3 branches and the many stakeholders to the process. Judges are in excellent positions both to convene and lead the work that needs to be done. All of the work done to date will remain just words on a page unless we as judges take steps to bring them to life. Before turning to the recommendations, I want to acknowledge the amazing staff who supported and led the subcommittee's efforts: Rick Schwermer, Patty Tobias, and Michelle O'Brien. The work could not have gotten done without them, and you're going to have the privilege in hearing from Rick Schwermer in a bit. There are 10 recommendations in the task force's report. The first is to deflect and divert cases from the criminal justice system. This recommendation is based on the simple fact that if we have fewer defendants with mental health issues coming into the criminal justice system, there will be fewer cases where competency is raised. Sometimes people land in the criminal justice system because at a time of crisis, the person standing in the middle of the street in the middle of the night, screaming and impeding traffic, leads to a call to law enforcement, and the easiest or only option is to drop the person at the jail, which triggers the need for a charging decision, the appointment of a lawyer, and if charges are filed, that leads then to an obligation of the lawyer to determine competency. So the questions that need to be asked are there alternative sites to jail for first responders to take people? Are there alternatives to law enforcement being called? We are all hopeful that the 988 system being implemented next year will help in the diversion efforts. Given the recognition that many people will land in the criminal justice system by default, in my jurisdiction, we've been working on a large collaborative initiative to build an crisis assessment and stabilization center to offer first responders an alternative to a jail drop-off. We've been impressed with the Harris County Center and have been fortunate to have been able to consult with Wayne Young as we move forward. The second recommendation is to restrict which cases are referred for competency evaluation. If criminal charges are filed, then competency can be raised whether the charges are misdemeanors or felonies. For misdemeanors, the process of determining competency may result in an individual spending far more time in custody than they would have if there weren't competency issues. Some states have, by statute, decided not to pursue competency evaluations if the highest charge that the person is facing is a misdemeanor, with the expectation that other systems are available to address the needs and issues of the person. For example, assisted outpatient treatment, civil commitment, or community mental health treatment. Some states are taking a more nuanced approach than a blanket approach of no misdemeanors, given the fact that charge-based decisions don't necessarily reflect criminogenic risk. The third recommendation is that alternative sites for evaluation be developed. In many jurisdictions, most competency evaluations take place in jail, not because jail is seen as the best, most therapeutic place for evaluation to occur, but because there simply aren't other alternatives. Locally, in my jurisdiction, we are working on a vision of the Crisis Assessment and Stabilization Center being a possible alternative site for competency evaluations than jail. The fourth recommendation is that alternative restoration sites be developed. If you have only one place where restoration can take place and the numbers of people found incompetent is rising, the result will be delays and untreated mentally ill people waiting. In many states, that one place has been a state hospital, and the time to admission, with people often waiting in jail, can be months and months. An issue that the Competency Subcommittee spent a fair amount of time discussing and debating was competency restoration services being offered in jail. This was a controversial idea, and we reached consensus that jails are not a therapeutic environment and that restoration services should be greatly discouraged and only offered when the wait to get to a treatment bed or a hospital for restoration means that the individual will be waiting untreated in jail for a prolonged period of time. Some states prohibit restoration in jail and have strict timelines as to how long an individual can wait in custody after a finding that they are unfit. One of the solutions to the issue of long waits for hospital admission is to develop options for community restoration for defendants who can be safely treated in the community. This requires not only adequate behavioral health and restoration services in the community, but adequate supportive housing. It is hard to expect people to engage in restoration services if they are simply trying to survive living on the street. The fifth recommendation is to revise restoration protocols. Once a defendant is found not competent, there is an obligation to provide the services for restoration. And generally, those are medication, individualized mental health treatment, and legal skills education. There's a variety of restitution processes between jurisdictions and sometimes between sites within a jurisdiction. Given the crisis in the competency system, as judges, we need to know what works best to restore an individual to competency and what is the sweet spot for the length of restoration services and what will help maintain competency once a defendant is restored until resolution of the case. There is research examining the efficacy of the different approaches to restoration and some consensus that medication is often a necessary catalyst for successful restoration. Additional research will be helpful to assure that we are not wasting time or money in how we restore people to competency. There's a wide variety across the states in terms of how long we should keep people in restoration services. Some states limit restoration to 60 days, where others allow for years. Again, further research on what time standards are most effective will be useful as we consider restoration protocol changes. The subcommittee also recommended that in looking at restoration protocols, that the courts take an oversight role during any period of restoration, whether the person is in a state hospital or whether they are being restored in the community. Again, that goal is to make sure that progress is moving forward and that we are using our scarce resources of beds or slots and not squandering them. The sixth recommendation is that we develop and impose rational timelines. In Jackson versus Indiana, the U.S. Supreme Court held that the nature and duration of an incompetent defendant's commitment must bear a rational relationship to the purpose for which they were being committed. However, we've all likely seen examples where the length of time a defendant is committed far exceeds the sentence they would have received if they were competent and bears no rational relationship to their level of risk or the nature of their crime. At each of these steps in the restoration process, there can be delays, and we need to pull apart the restoration process, examine the points of delay, and then come up with solutions for rational timelines and processes. We did not recommend a single or model time standard. Jurisdictions differ in terms of resources allocated to the restoration process and in what areas consensus is possible. But we do recommend that jurisdictions examine each point along the process to determine whether and what the presumptive time standard should be. The seventh recommendation is that we address operational inefficiencies. When we dig into the operations of the competency process, it is easy to find inefficiencies that bog down the process all along the way. We know that we need a sufficient pool of evaluators. That leads to delay when we have insufficient numbers of evaluators. And we need evaluators who are well-trained, understand the competency process and the findings that need to be made. One of the recommendations that we talked about is developing evaluation templates so that when you're seeing an evaluation, you know that it's going to have the necessary information in it for you to be able to make the decisions that need to be made. There are some jurisdictions that allow for multiple evaluations to be done if the defense and the state are not in agreement. We believe that jurisdictions should look at ways of decreasing the number of evaluations, because the more evaluations that need to take place adds both to the expense and the time to a determination of competency. We saw case managers and court liaisons as something that courts should look at in terms of helping the efficiency in the system. Case managers and court liaisons can help explore and make referrals to appropriate community placement, keep track of people, keep track of what beds are open in order to prevent further delay. And finally, we looked at what the court can do in terms of case management, whether court should implement a centralized calendar, whether there should be frequent reviews of competency cases, and whether the court should encourage and develop competency teams consisting of lawyers for both defense and the prosecution, and a judge, all of whom have experience in the competency arena. The eighth recommendation is that we address training, recruitment, and retention of staff. A consistent theme that we heard from every jurisdiction was that many of the inefficiencies in the competency process can be traced back to the lack of sufficient behavioral health workforce. I know that in Oregon, I've been on a number of meetings this week discussing the crisis in the behavioral health workforce and are there any solutions? We haven't got there yet, so if you all have solutions, send them my way. The ninth recommendation is that we coordinate and use data. We all know that we can believe that we are doing a good job, but data really tells us and holds us to the mark. In Oregon, we have developed a aid and assist dashboard and that is able to track what's happening real time for each court in terms of the numbers of people that they're committing, what kinds of charges they're committing people on, what delays there are, both in terms of getting evaluations done in transport, et cetera. Our judicial department has developed that. We would love to have then the benefit of also data from law enforcement and jails and treatment providers to really give us a full view of what's happening in the competency arena. And finally, we need to develop robust community-based treatment and supports for diversion and reentry. This recommendation had the most consensus among the trial judge focus group and on the subcommittee. Across the entire treatment continuum, across the entire criminal justice continuum, we know that we need more treatment for the forensic population, and even more importantly, we need adequate supportive housing. We can't get people safely out of jail unless they have the kind of housing that is necessary. We can't restore people and then release them if there is no housing and expect them to maintain their competency. So those are the recommendations, but the work of the Task Force Subcommittee on Competency is not over. The next stage of the work will be to provide some of the products that will assist jurisdictions in implementing the 10 recommendations. It's clear that the recommendations all require that all three branches of government and the community work together and reach consensus on solutions that will work for their community and jurisdiction. Judges are uniquely positioned to act as conveners, and I would urge all of you to do so. People generally respond when we send out an invitation, and we are viewed as objective given our roles. I would urge all of you to continue to use your positions to achieve the system's improvement to the competency system that is sorely needed. I look forward to continuing to look to Texas and other states for your innovations and solutions. Thank you.
We only have a few minutes, but if you've got some questions here, and there were a couple in the chat, there was one in the chat about sort of restoration and what that really means, and legal education. And it gives me an opportunity to remind you what I said before, is that there is research, there are programs out there that tell us what the best practices are. And so, for example, there's research that distinguishes between different protocols for restoration, and it suggests that the legal aspects, or there are 3 different kinds of restoration services usually. There's a legal aspect, hopefully there's a treatment aspect, and then there's a medication aspect. The research tells us that the legal aspect is the least effective and the least important of the 3, the least impactful of the 3. So no, is that restoration? No, it's not particularly good restoration if you're looking at long-term outcomes, just to educate somebody about who sits where and what role people play. Does it meet one of the dusky prongs? Yes, but not the second one. So that's just an example of the resources that hopefully we have for you. I left my clicker. On each of these topics. And there was another question that said, well, weren't these states sued? Yes, there have been over a dozen states sued because of these competency delays. I don't remember if Texas has been or not, but pretty much every state that has been sued has lost. The system has lost, and the advocates have won. So as you go back to these 10 recommendations, the other one thing that I want to point out is that the first 4 are all about getting people away from this process. Yes, 6 of them are about improving the process, but the first 4 are, let's do something different. Let's divert and deflect them from this process that we know does people harm. And I think that's a terribly important message, and again, one that you all have a role to play. So just in closing, let me tell you about, I see your hand. If you want to grab that mic, I understand folks can't hear. The last thing to mention is about resources that I mentioned. The Behavioral Health Resource Hub is part of what we put together as part of this task force project. It deals with competency, but it also deals with everything else along the range of the sequential intercept model, where we've pulled together all the best research, all the best pilot programs, articles, whatever there might be, so that you can go and look up anything, crisis intervention, that may help you with whatever your problem is or whatever your issue is relative to the behavioral health intersection. Did we have a question over there?
I'm from rural West Texas. We do have a state hospital, Big Spring State Hospital, which is full of forensic patients and not available. I hear all this. We have task force, we've done all this stuff, but when it comes right down to it, we do not have the resources we need.
Right.
I find people incompetent to stand trial after evaluation because they need help. And it's not my jail, but there's not a bed for them anywhere. And
Right.
so the problem is resources. We need more resources. We need more places to send them where they can get help. Rural West Texas doesn't have that. And so it's a dearth of resources, no matter how much we study it, how many task force, how many incentives. The bottom line is we don't have the resources.
Yes. Yes, and, not but, and most of the recommendations that we make save resources and allow those resources, those beds you do have, to be better spent, better used on the folks who really need it, rather than the misdemeanor who doesn't need one of those beds. Let's do something different for them. And yes, we need more resources. And so, for example, let's not do 5 evaluations of somebody. Let's do 1 and see if there's an objection. There are a lot of ways in which you could redirect the current resources. And yes, we also need more other resources that, by the way, the research tells us is cheaper and more effective, like outpatient restoration, like outpatient evaluations. And the other thing we can bring to bear right now, based on our pandemic experience, is technology. There's a ton of research that tells us that, for example, competency evaluations can be done just effectively, if not more effectively, remotely, so that you have your folks in your metropolitan areas that can help do the evaluations remotely in West Texas. There's a whole section in this resource hub on resources just for rural jurisdictions. So I agree with you, and there are a lot of recommendations in this paper that speak to better use of community and other resources, and also how to expand them. Sure. Homelessness of the unhoused is a huge issue as well. It's related. As you talked about risk yesterday, mental illness is a responsivity need, right? In other words, you got to address somebody's mental illness in an appropriate treatment context before you can get them substance use disorder treatment or criminal thinking treatment that works. So all of these things come together, and that's again why this is an integrated national perspective that says we need to get folks working on homelessness, on substance use disorders, on all of these issues. Housing was a huge issue among our focus group judges. Absolutely, and we have some resources relative to that on our site as well. Final thing, we do every 2 weeks a behavioral health alerts, a newsletter that should have come out today. I did it last night, but it's being published. Here's the address to sign up for that. It's all the stuff that's happened in the last 2 weeks relative to behavioral health and courts intersection. I encourage you to take a look at that. That's where you'll find the most recent research, all kinds of cool stuff. Thank you for your patience. Thank you for your questions. Thank you so much for inviting us to be here, and I look forward to eliminating the wait, our next topic. Thank you.